You have questions, we have answers. This is Jane Miller.
And this is Ken Miller. Welcome to our show, all about real estate with Ken and Jane. So back by popular demand, we're going to talk about landlord and tenant, one of my favorite topics personally to talk about.
You know why Ken says it's his favorite topic? Because every time I have my client call, I will happily to ask Ken to return their call.
Exactly. Right. Yeah. So we should preface the conversation by saying this show is just guidance.
It's not legal advice.
We cannot give legal advice. We're not landlord tenant attorneys. So everything we're going to say
it's just a
public information discussion that we've got from reviewing the residential lease, the realtor lease, and also from the Truth in Renting document that's published by the Department of Community Affairs. That's what
we're going to get.
Plus our experience. And again, it's just
not
guidance.
Advice. It's not a guidance.
And the only one who can give you legal advice is an attorney that's experienced.
Yeah, it just share our experience, right? I mean, that's not even a guidance.
Right.
How you want to proceed, you should seek legal advice.
Right.
This is just a chat.
Right, so a chat. So leases in New Jersey, we're going to talk about residential leases, they can be oral, or they can be in writing. It's recommended for a realtor. It's always in writing, and it's highly recommended that if you're doing a lease, that you might put it to writing because there's
always writing, Ken.
So there's no. I'm just saying legally that some people may be operating on oral leases, which but
you
it becomes
never
harder
can argue something.
Right.
What I think, what you said.
Right, exactly right. So what should go into your lease? Well, I'm going to follow the template of the New Jersey Association of Realtor Lease, which is the pre-printed lease that realtors are allowed to fill in the blanks, and any lease is going to have the names of the parties, the landlord, the tenant. It's important that all tenants be noted on the lease, so there's no ambiguity in that. It should have the address of the property. It should have the term of the lease, whether it's for 1 year, 2 years, 3 years.
Month, days.
It should have the rent amount. It also should have the late payment penalty. If the rent is normally there's a 5-day grace period to pay the rent, but if the rent's due on the 1st of the month and the rent isn't received by the landlord by the 6th of the month, it should have a late payment penalty provision, which has to be reasonable, but that has to be specified. And if the
let me interrupt you, which I always do.
Right, yeah. So,
about the grace period, right? I mean, I want to just say it out loud there. It's a grace period. I do see from time to time, not often, I do see from time to time, some tenant just think that's their rights. That's why they call it a grace period. That means you miss the payment.
Right.
If on the contract have a different date. Normally, generally speaking, is 1st of the month, but the landlord and tenant can mutually agree on different date, right? But the 5 days from the day due is grace period. Right. Don't use that every month because, for example, right. I had a tenant a long time ago. So the first month is on time because they give the final walkthrough, right? They took the key. After that, every month they were late. They always late.
Well, it's not legally. It's not late, but it's
But Ken,
rent is due the 1st of the month, so they're within the grace period.
Legally, it's not late. Because it's legally, I'm not a lawyer here.
Right.
I'm not a lawyer. Right. You are. I mean, legally it is late, but you have a grace period. You don't have to pay pay the late fee, but that means you're not late, right? But the story is the tenant always late, 11 months. So after that, they want landlord to give a reference because they move to another city. So actually 2 months they stay there, 2 years. And then another city called landlord asked for the reference. They asked how many times the tenant rent was late. And the owner said 23 times because only the first month was done at the final walkthrough. Once again, and then tenant calling me and said that, what's going on, what happened. I said, I don't know because he gave the landlord phone number. So, I said, well, you were late.
I see.
But I think next time he doesn't use the landlord as a reference then.
But a lot of times when you screen an applicant, you ask for the landlord references from at least if the tenant has lived for the last 2 to 5 years, you want to know the history because that's an important source when for the agents that are screening tenants on behalf of the landlord. You want to know the payment history, you know, what type of tenant you're dealing with. So I think that's so.
The landlord said he had 23 times.
So if an applicant doesn't, so if a tenant applicant doesn't give their prior landlord information, then that should raise a red flag. Should go up and say, hey, what's going on? What's going on here, right? So anyway, getting back to this, the late payment has to be if. That's something that in the New Jersey realtor lease, it's specified as additional rent and that's a very important legal term. If it's additional rent, it means that the landlord can enforce it if there was, you know, as rent, meaning if it's not paid, then it can, you know, it could have legal implications if they were to go for eviction. So
that's already in the lease.
That's already in the lease, right? Other things the lease has that I'm just again using the template of the New Jersey Realtor Association. They have the utilities, who's responsible for paying the electric, the gas, the water, and the sewer. That has to be specified. The maintenance responsibility is what the tenant's responsible for in terms of repairs, what the landlord's responsible for in terms of repair. Another important provision is renter's insurance. Now, it's already specified in the New Jersey Realtor lease that the tenants must maintain renter's insurance to cover their furniture, personal belongings, clothing, and also including liability.
Liability. It's
very, very important that it's also in the realtor lease. Oftentimes associations that allow owners to have rent to tenants, they mandate that the tenants have renter's insurance because God forbid there's a flood, there's a water leak, and it ruins the tenant's furniture. They have to have coverage for their personal contents.
You know, Ken, long time ago, I'm talking about a really long time ago. We had an issue, right? At that time, there's a brand new building, so the tenant said they don't want insurance. Okay. But it's up to individual. That time, you know, obviously now you can't even go through it because the association
you wouldn't get through it, correct?
Now you won't. But 17 years ago, you know, the rules wasn't that clear. So so
they would do a waiver sometimes.
We asked the tenant to write a waiver to waive the landlord and the agent, like myself, waive the liability. But we tell you, but the story for that was the brand new construction. But upstairs, the water heater gave it out. So the flood the whole house. So the new TV, everything is gone. So after that, right, I mean, the damage is huge. You would think the brand new construction, what can go wrong, right? It's just the new hot water heater just blow up. It's just like leak that day. So after that time, we informed our landlord clients, every single of them, unless the tenant agreed to give a insurance, we recommend don't take them. Forget about the waiver. There's no more waiver. And thank God we did that. But a few years later, all the association they insist on that. But we were well before because one property, you know, even though there's no the tenant signed a waiver and there's no liability for the landlord and the agent, but our job is protect everyone.
Of course.
So we want to make sure
you want to mitigate any problems.
If you refuse to buy insurance cover yourself, protect yourself, that may not be the right tenant we want to take in.
Right,
so,
right.
Yeah.
And I believe the associations are getting smarter too, because if it's the same association that I'm thinking of that you're mentioning, that particular association now came out with an ordinance that requires the hot water tanks to be replaced after 8 or 9 years because of the damage they caused, because it was a flaw in the design. They they put in these expensive hot water tanks based on the heating system, but when they fail and they go right beneath the utility closet below, and it damages all the
whole
ensuing
house,
and that was just not a very smart design. So now the association got wind of it, and they said, hey, this is to prevent this. We were going to mandate either you provide documentation, the age of your hot water tank, or you have to replace it.
Yeah, but that time was only about 2 years old at the time.
Well, I don't know what happened.
So
Then
something just didn't work out.
Yeah.
That's why you buy insurance again.
Yeah.
If you're sure the bad thing gonna happen,
no. We've had to use it.
Insurance.
We've had to use it too in that one development, and it came in very handy because those hot water tanks in particular are very costly because they're specialized equipment. They're not just a standard hot water tank.
Yes.
And so they're like over $2,000. And it's so you have to have insurance, otherwise you're going to get hit with a large bill if you're the owner.
Yes.
So renter's insurance is very, very
Important, extremely important.
It's critical if you're a landlord and if you're a tenant too. You want to protect your contents.
You protect yourself.
It's not all that expensive for peace of mind.
Nothing for nothing, Ken. The insurance protect yourself. I mean, we do have a friend, right? They are renting, and then the friend, the children friend came and got beaten by their pet, right? So you have to have insurance to cover that.
It covers your liability.
Yeah, liability. I mean, another time there was like in the house, my client rented the house, and then I think there were children play on the steps or something, right? And then one child fell.
Yeah.
The two kids, they were just walking down and then they play with each other. One thing they both flat on the ground floor. So, one parent decided to sue the landlord, to sue the tenant.
I think that happened, unfortunately, in the dog case you mentioned. I think that happened with somebody, a client in Central Jersey, that unfortunately they didn't have the tenant was in between getting the policy instated, and it just so happened it was like Murphy's Law. Just when they didn't have it for that slight window is when the dog came.
I mean, even you have the insurance, Ken, you have to buy the right insurance because if you have a pet, you have to mention that on your policy.
Of course, otherwise,
so a lot of time you have to really, take a good care to protect yourself. This is not the landlord or landlord agent to give you a hard time. It's truly protect you. Tenant
it's
as
your
well.
best interest. Yeah.
Yes, absolutely. Things happen, like I said earlier, two kids play and walk from upstairs to downstairs. They will like poke each other and play. And next thing you know, they both lost their feet and flattened on the ground. And one parent decided to sue, So the things happens, right? It's like, they were best friend. And after that, I guess, no longer, right? Because the parents, not the kids still good together at school, but it just parents wouldn't let them to play again together. But you can't. I mean, once again, void. A lot of things you can't void, but maybe insurance will help you to deal with it afterwards.
Absolutely, that's what
to
insurance
reduce
is
the liability. Yes.
Yeah. Absolutely. Another provision in the lease is the pet provision.
Yes.
The lease has to specify what pets. The New Jersey Realtor lease basically states that no pets are permitted without the consent of the landlord. So it leaves it open for that. But then normally with leases, there could be an addendum saying either no pets are allowed or a small dog is allowed or a dog and a cat are allowed. What type of animal.
The landlord should add that to his and her policy as well.
As well, of course.
Yes,
and then
you have to add that.
And then you would put in language in the addendum that the dog or cat or whatever pet must be updated on its license, registered with the township if required, and up to date on vaccinations and all.
And also association if
and then also follow the waste disposal procedures for the pet. So it's important that all be noted and specified in the lease, so you have a control on how many pets are there.
Yes. So often things like we always say that addendum in the lease that's existing pet, because sometimes people don't have a pet, add one, or one died and get another two. So that's something you have to inform the landlord.
Right.
That's agreement between the tenant and the landlord. Before you get one, you have to get landlord approval first.
Yeah. All right, we're going to let the listeners take a coffee break. We'll be right back after these messages. Please stay with us. Okay, welcome back. So let's continue, Jane, talking about some of the provisions in the New Jersey Realtor Association lease. One important provision is paragraph 33, which is attorney review. It states that either the landlord or the tenant may choose to have an attorney review this lease if they so elect. And then the attorney, if he or she is going to have the attorney do it, the attorney must complete their review and initiate a proposed modification within 3 business days. Otherwise, the realtor lease, as signed with whatever additional provisions are added in that paragraph, becomes binding.
Yeah.
So
I always advise the landlord, if they wish to have a lawyer. Once again, this is your rights. You have rights for your attorney, but if you chose not to have an attorney, which is that's your decision. You don't have to, but yes, you're right. If you do choose to have your attorney, especially for the landlord, I always make sure to give them the agreement first, so they can review it to make a suggestion already. So in that case, we have a lease ready. When we find the right tenant, we can share that already reviewed by the landlord's attorney lease to them. If they want to hire an attorney to make a adjustment, they can. And so in that way, we'll speed up the process because the rental come very fast. If you have a 1, 2, and sometimes, you may have a 3, 4 applications. So I just always, if any homework I can do before, I want to make sure I do that before we put on the market. Yeah, or as soon as we put on the market. Yeah, because that realtor's lease is a standard. So you can just
it's a statewide lease.
Yeah, you just email to the attorney. So take 2 seconds. Yeah.
Yep. Another very important thing to protect the tenants is the lead-based paint provision, which applies to dwellings built prior to 1978. The tenant must be provided a copy of the EPA pamphlet, Protect Yourself from Lead, and along with the lead paint disclosure form that's completed, the top half is completed by the landlord, basically stating if the landlord is aware of any lead-based paint, and if it's a disclosure, and then the tenant has to sign it, and both agents have to sign it as well to acknowledge that, because lead paint is no joking matter. It can be very serious. There's been severe lead-based paint poisoning cases, documented where, fortunately the children were eating the paint and,
That's, by the way, that's only for the homes built before 1978.
Correct.
Yeah. I did have people ask me about it, but their house built in 1979. So I said, you just missed that, so you don't have to worry about it.
Fill that out, right?
Or nowadays, if you want to rent, you have a lead paint inspection,
right?
So you don't have to do that.
Now for the homes, for the dwellings that have lead-based paint, you have to have you have to have it certified every I think it's every 2 or 3 years. That it's a safe, or you can choose to have an inspector come in and give you and determine that they're actually in the home. If the dwelling was built before 78 and they inspect your apartment unit, they can give you a lead-free certification if they do the actual XRF testing and determine, hey, there's no lead-based paint in this dwelling. Then you have a lifetime certificate, which which certain landlords have done and gotten. But but otherwise, if you have lead-based paint and you don't go for that lifetime certificate, and every couple of years you have to have a lead-based paint inspector come in and make sure that there's no exposure hazards to the occupants.
Absolutely, yeah.
Another important thing in the realtor lease is the window guards. Window guards is something that the tenant can request the landlord to install as safeguards for the windows, obviously for second stories, and also first level if the windowsill is 6 feet or higher from the ground, or it can be lower if there's certain what are determined to be hazardous situations. So that's like a case-by-case judgment. So that's spelled out. If the tenant makes a request in writing, then the landlord has to do it. And if it's in an association and there's common hallways, then the association would be responsible for installing window guards in the common areas, where the landlord is responsible for installing the window guards in the private unit itself, right? Here's an interesting one: security cameras. That's very popular now. When realtors get out there and they start showing homes, a lot of the sellers, they install security cameras, because they want to keep an eye on their house, especially when agents go in and when buyers go in, and just to make sure everything's in order. Now, if you're a landlord and you have security cameras installed in your home, when a tenant goes in to occupy it, those security cameras must be disabled. They cannot have like nanny cameras, security cameras. The tenant has a right to privacy when they're in the unit, and that means that there's no security cameras, no third party watching them.
That's even though it's a common sense, but sometimes you may forget. So you just make sure you disconnect them. Or disconnect the service, Right. Now, another very important document, which we touched upon in the beginning of the show, is the Truth in Renting document put out by DCA. That's a document that must be given by the agent to the tenant and also to the landlord before the lease is signed, so they can review it. And the Truth in Renting document is a pretty thick document. It spells out all the rights and responsibilities of both the landlord and the tenant. It's very, very important. It goes into a lot of issues. Basically, it covers the requirements of the lease. You have to be at least 18 years old to sign the lease. You must be mentally competent. It must be in plain language, meaning understandable to the common person. That's the definition of it. And again, any fees that the landlord intends to charge as late fees must be expressly
stated in the lease. If they want to recover attorney fees, they must put that into the language of the lease.
But by the way, if you use the realtor, the standard realtor association lease cover. That's a thick document. It's covered everything in that. Yeah,
right.
They're already automatically covered. But if you want to do yourself, I know a lot of landlords rent out themselves. I mean, some people just want to use online now, the AI service to produce one. I would highly, highly, highly recommend you to consult the attorney. Okay, because the online free service is good for
it gives you maybe very guidance, but everything with leases is
legal. You need a attorney because you don't want any in trouble if you have a dispute. You took a lease to the court and the court found the lease is not it's not legal or cannot be enforced. So you want, if you have a lease, you want to make sure the lease is done right at the beginning. So I highly, highly recommend that if you want to do it yourself, please have your lawyer to review it. At least you had a legal advice on that. Yeah, to make sure the lease is correct. Yeah. Mm-hmm.
Right. Okay, now here's a very interesting topic, lease renewals. So let's say we have a lease from June 1st, 2025, that's a year lease, so it expires May 31st, 2026. Neither the landlord or the tenant takes any action, even though the lease says, maybe if they're using the realtor lease, it says within 60 days before or 90 days before, the landlord shall notify the tenant and propose the renewal terms. The landlord doesn't take any action. The tenant doesn't take any action, but the tenant has every intention of just continuing to stay there and pay rent. So the question is, what happens if after May 31st, 2026, in our example, what happens to the landlord-tenant relationship? Does a lease terminate and the tenant must move out, or does the tenant have rights?
Once again, I had a money quote for that because a lot of landlords think they don't have a lease.
This is a big misperception.
You have a lease.
It automatically continues. It reverts to a month-to-month lease. Yep. And in New Jersey, the rule is that basically the tenant has a right to continue in the lease as long as they're in good standing, unless the landlord has just cause to ask them to leave at the end of the lease, to terminate the lease. And what are some of the reasons? What the heck is just cause?
I think one is if the owner want to move in themselves.
If they truly want to move in themselves, that's one reason.
Yeah.
Other reasons.
But truly moving yourself, not just use the excuse, get rid of tenant, and then you rent to someone else. That's not right. You have need to move in yourself.
Right.
Or you want to sell the property.
Or they want to sell. That could be some examples. The other ones that are common are just if the tenant has engaged in disorderly conduct and
that's your
illegal activity, crimes, drug activity going on there. Willful damage to the property. But then in those cases, then again, this gets into the lawyer end of it. If you want to remove the tenant for those reasons, you either have to give a notice to quit or a notice to cease. One of them is a notice to quit is like a warning, whereas a notice to cease tells a tenant to stop it. Otherwise, you're going to get removed. A notice to quit. So that gets in. We're not going to get hire a lawyer. That's beyond the scope of this discussion. That just gives you the roadmap. If there is an issue, and hopefully you resolve any issues with the tenant, and I
have something funny to tell, right?
But
both landlord and tenant, just as you said, Kim, nobody did anything. And May 31st, okay, and now it's not May yet, but I'm just saying, at the end of the lease end, the tenant once again, during this time, as you said, nobody contact each other. The last day of the lease, like 6 o'clock, the tenant texts the landlord and saying, we moved out. And how do you want me to give you the key? I can leave it under the mat. Or if you have, you have your spare key, I can lock the door from the knob. I just can lock and leave the key on the kitchen counter. So we're out. So the owner
Which the tenant has the right to do, by the way.
The owner shocked, called me up, said, oh, they need to give you notice. I said, no, they don't.
It doesn't work that way. The tenant can move at the end of the lease if they so desire, but the tenant, if they choose to stay, the landlord has to, like you said, they have to honor
the other way around.
Other way around, that's correct.
So I always advise our landlord. Now the Google Calendar is so popular, you should
put on your calendar 90 days before.
90 days before. Put 90 days or 92 days before. So you if you're busy one day, you make sure you
and we should
reach out.
We should also touch upon the rent increases. Rent increases you have to check with the township that the property is located in, because some townships have a cap that you can only raise the rent based on the consumer price index. Others may have no restrictions, but you need to know what the regulations are that govern your jurisdiction. And then the rent increase still has to be reasonable.
Yes.
And that you can't gauge the tenant, and reasonable is based on the facts. It's fact specific.
Absolutely.
There's another important thing we want to talk about is the security deposits, which is a very, very popular topic. And we have about 2 minutes left, so let's just touch upon that, then we'll conclude. The maximum security deposit allowed in New Jersey for a residential tenant is a month and a half of the rent. It must be placed by the landlord in a landlord-tenant interest-bearing account. Within 30 days after opening the account, the landlord must notify the tenant the location, the bank name, the account number, the interest yielding, all that information. The security deposit is intended to hold for the landlord until the tenant vacates for true damages. Now, we talk about damages versus wear and tear. That's where it gets a little bit tricky. Damages would be things that are broken versus, the unit needs painting. Oh, the tenant was here for 2 years. I think I'm going to repaint the whole unit and charge the tenant, take it from the security deposit. That's a big mistake.
Yeah, I think anything deduct from the wear and tear or damage, you have to have agreement in writing.
Yeah, you have to,
because otherwise, the tenant can.
And the bottom line, we don't have time to get into it, but you have to then anything that the landlord proposes to deduct, you have to send an itemized deduction list with receipts for any damage that's deducted from the security deposit. And if you don't do that within 30 days and you wrongfully withhold security deposit money, the landlord could be liable for 2 times the amount that's wrongfully withheld from the tenant in court, and the tenant has that very right. So you have to be very careful with security deposits that you follow the rules.
Yes.
So we're just out of time. We hope you guys enjoyed the show, and we'll see you next week.
Have a good weekend.